and if so, whether they can be damaged or destroyed by an amending power, pp. 506, 507. The substitution of the word amcndm, CNT by the expression 1 amcn by way of addition, variation or repeal make, sees no difference as it bears the same meaning as the word amendment. It is apparent from the meaning of the word 11a amendment that it does not include repeal or abrogation, nor is it the same as revision. A repeal of a provision of law is different from the repeal of the law itself. The Constitution itself has, in various articles, made a distinction between the amendment of the law and repeal of the law. The word amendment, as used in Article 368, does not connote a PLC of power. The word read with the other provisions indicates that it is used in the sense of empowering a change in contradistinction to destruction, which a repeal or abrogation would imply. Art. 368 empowers only a change in the Constitution, as is evident from the proviso, which requires that where the provisions specified in clauses A to E have to be amended, they have to be ratified by THP resolution of not less than 1/2 of the legislatures of the states. It cannot be enlarged by amending power under proviso E to Art 368 up 508 to 512. Goyaknath v. State of Punjab 1967 2 SCR 762 Queen v. Bura 1877-78 PC 179 referred to Rhode Island v. Palmer National Prohibition Case 64 Led 946 explained, if the entire Constitution cannot be abrogated, can all the provisions of the Constitution leaving the preamble, or one article, or a few articles of the original Constitution be replicable, and in the place other provscion, placed V1HCRC by the entire structure of the Kusatan, on the power or clanonch 1p inter C3 departments the federal character of Thetau, D the rights of THC citizens visa, Phys the state arc abrogated and new MSTJ, Tunons, power relations 1p's and the fundamental features substituted therefore I such an attempt would equally amount to abrogation of the Constitution, because any such evkais of thir will merely cave the husk and will amount to the subsol. Tutton of an centrally new Constitution which it is not denied, cannot be done under Art 368p. 512. The preamble to the Constitution de clario. The purposes and objectives which the Constitution is intended to subserve, the preamble. It'll furnish a guide to the construction of the statute. Work the word arebi, us or elkavend where the words are unambiguous to aid a comtruetan, which odo absurdity ikrak preamble, cvcy as a kelke and definited jai. EW, prevail over the connecting words which are relocally obel cut c or, which fits the words are capable of more than one construe claw. The construction I to the preamble may be preferred, in Re-Beruhari Union Court, to refer to and consider the view that the preamble can be, to 38 Supreme Court Reorts, 1973, subscribe the nature, extent, and D1 application of the PO. Cursor that the preamble can be resorted to prevent OBY10UJ absurdity, or to a direct overthrow of the intention expressed therein, 512 to 516. In Re-Berubari Union E. Fanj of Enclaves, 1961, SCR, Saijan Singh Devire, State of Poon 1AB, 1965, 1 SCR 933, Aloar NL, Enerol Yer, Prince Barnell Augustus of Hanover, 1957, AC 436, and Bowell VK Nempton Park Rack, Coel JJ, 1899, AC 143, referred to. If a constitution is considered as a mechanism or an organism or a piece of constitutional engineering, it must have a structure or a composition or a base or a foundation. The clements of the basic structure arc, indicated in the preamble and translated in the various provisions of the preamble. There is nothing vague or unascertainable in the preamble. The edifice of our Constitution is built up CM and stands on several props, remove any one of them. The Constitution collapses. These are I. Sovereign Democratic Republic, Justice, Social, Economic, and Political. Omridum 3. Liberty of thought expression, faith, belief, and worship. Equality of status and of opportunity. Each one of these is important, and collectively they assure a way of life to the people of India, which the Constitution guarantees. If any of these CLCR and CNTs is withdrawn, the structure will not survive, and it will not be the same constitution, nor can it maintain its identity if something quite different is substituted in IU place, which the sovereign will of the people alone can do. What then are the essential features or the basic ELCMACNU, comprising TTM-DORI structure of the Constitution, need not be considered in detail as THECLC will fall for consideration in any concrete case, where they are said to have been abrogated and made neon kixis ken ta sovereign.